Hello everyone, I'm Dr. Kalpana. We are going to learn today about a concept of company law, which is very important and popular topic of corporate law, lifting the corporate veil. Veil means in Hindi we call ghungat, parda. So, well, as you know, after incorporation of a company, it acquires its own separate legal existence. So, corporate will represents a fundamental legal doctrine that distinguishes a company as separate legal person from its shareholders. And this principle was established in a very famous case that comes from 1897 as a judgment of Privy Council, Salmon versus Salmon and Company Limited. And this principle affirms that upon incorporation, a company gains an independent identity under law. And Section 9 of Companies Act 2013 reiterates this legal status so far as Indian law on company is concerned, emphasizing the company's separate legal existence from the date of incorporation. Such legal separation safeguards members from personal liability, fostering entrepreneurship and investment while maintaining predictability with commercial law. Now, proceeding towards understanding lifting, or interchangeably, it is called piercing corporate veil. Lifting or piercing corporate veil denotes judicial intervention wherein courts disregard the company's separate legal personality to hold shareholders and directors personally accountable or liable. And this doctrine is invoked primarily to thwart the misuse of corporate form. Whenever that advantages for the purpose that separate legal entity has been created by law, uh, as we have already discussed about it, limiting the liability of the shareholders and people who are the stakeholders. So court pierce the veil to prevent fraud, tax evasion, avoidance of legal duties, acts contrary to public interest, and by doing so, they ensure that the corporate entity is not misused as shield for dishonest or unlawful conduct. So, in bullets, we need to understand under what circumstances and under on what grounds court is authorized to intervene when it comes to lifting corporate wealth. Fraud prevention is the purpose when it comes to the notice that fraud is being done under the veil of corporate existence. So, ensuring companies are not used to perpetrate deception under its shield. Second thing, tax evasion is one of the common misuse under the shield of corporate personality, stopping owners from hiding behind corporate identities to avoid taxation, because taxation is one of the biggest source of revenue for the government of any country. So tax evasion is very much common by the companies. They try to, so we are not going into such kind of details. Legal obligation enforcement, maintaining compliance with holding individuals accountable despite corporate separation. So here, maintaining compliance means individuals are also accountable despite corporate separation. For example, if directors are found to be engaged in any kind of fraud, tax evasion, or violating public interest or public policy, they may be personally held accountable under Companies Act 2013. Public interest protection is something which is on utmost priority. So safeguarding society from abuses of corporate structure, that has been taken into consideration on priority, because whatever we do, a society should not be harmed. As a public large, it should not be the victim of any kind of benefit uh, under the corporate existence. Judicial grounds for lifting the corporate veil. Court intervention to lift the corporate veil is strictly reserved for specific instances where misuse or abuse is very much evident. Not just like someone is filing the complaint and court is so much, available for intervening into corporate affairs. So such judgment emphasize protecting the integrity of the legal entity principle while addressing abuses. So common ground include the fraud, tax evasion, avoidance of legal duties, means non-compliance of for which companies are liable for that legal compliance is something which is very important part of corporate governance. Agency or trust arrangements and enemy affiliations during wartime. So fraud or improper conduct, where we do have a landmark case, Guilford Motor Company versus Horn, 1933. The court pierced the veil as company was a sham to evade contractual obligations. Avoidance of legal obligation, Jones versus Lipman is also another landmark case, held the company as mere the facade to avoid contract enforcement. So look at this. We have a flow chart here. Tax evasion, look at this. First is fraud or improper conduct. Second is tax evasion. Third is avoidance of legal obligation. And fourth is enemy character, for which we do have the case when it comes to tax evasion. Reser, Dinshaw, Manik G. Pettit confirmed well lifting where companies were used to reduce tax liabilities. Enemy character, Daimler Company Limited versus Continental Tire Rubber Company is a very famous case addressed the wartime control by enemy aliens. Statutory provisions mandating veil lifting when that can be pierced. Beyond judicial discretion, we have statutory laws explicitly mandate the veil lifting under certain circumstances. These provisions ensure corporate transparency and accountability. They include provisions in Companies Act, tax statutes, regulatory acts addressing incorporation fraud, improper striking of fraudulent business conduction and regulatory compliance. First is Section 7, Subclause 7, false incorporation information. That is one of the provision. Section 251, Subclause 1, fraudulent striking off. Section 339, fraudulent business conduct. Other regulatory provisions are also there other than Companies Act. Income Tax Act 1961, prevent tax evasion. SEBI Act, security fraud when it comes to share and participating in equity market, where SEBI Act comes into picture. FEMA, foreign exchange violations. These are separate acts which are also being invoked in under certain circumstances. There are some exceptions and limitations when it comes to lifting the corporate veil. Court caution governs veil lifting. The principle is not disregarded lightly because there are a lot of people whose future and life is on stake when a company is under such kind of intervention by the court. So corporate wealth remains intact where no fraud or wrongdoings exist and corporate structure is lawfully used. This maintains legal certainty. So seminal idea of the case of Salmon versus Salmon reinforces that companies legitimately formed will retain its separate identity, even if it effectively comprises a single individual preserving corporate protections. No wrongdoing evident. Evident means when it is very much on the face of it. Court refrain from intervention absent improper conduct, not based on any complaint or unless court finds it that wrongdoing or abuse of corporate existence is very much evident and it is very much looking at the face of it. Legitimate corporate use, so structures lawfully employed are respected. Public policy considerations, well lifting occurs only when public interest demands, otherwise not. So it's not easy. Contemporary judicial trends. Indian courts increasingly emphasize economic realities over mere formalities when it comes to applying well lifting doctrines. There is a marked shift towards substance over form, especially in public interest and taxation contexts. In Delhi Development Authority versus Skipper Construction Company, Supreme Court pierced the veil to prevent evasion of legal decrees, underscoring judicial willingness to scrutinize underlying realities. Substance over form means court focus on actual control and misuse rather than formalities. Public interest litigations, well lifting applied to enforce public interest mandates. Taxation enforcement, which is very significant, closure judicial scrutiny in tax related matters because government is directly stakeholder when it comes to tax collection is concerned. Corporate wealth and group companies or multinationals. So, well lifting in group companies and multinationals involve a detailed examination of ownership, control, and economic realities. Court assess complex structure for potential misuse in transfer pricing, cross-border mergers, acquisitions, or anti-competitive conduct. So this scrutiny ensures corporate groups do not exploit personalities to undermine legal or regulatory obligations. Control and ownership patterns analyze of who truly controls companies within the group. Regulatory concerns means compliance with competition law, tax law, and disclosure requirements. Cross-border transactions means here ensuring transparency in multinational dealings and pricing. Practical implications and conclusion now. So, doctrine of lifting corporate wealth has far-reaching practical implications and consequences. Corporate governance demands that directors avoid misuse of company structure. Startups must comprehend limits of liability protection, while investors should conduct thorough due diligence beyond corporate form. So, a judicial tool balances foundation of separate legal personality with accountability, ensuring the company is not mere puppet for fraud or dishonesty, as emphasized by Law Denning. Corporate governance upholds ethical use of corporate structure and legal compliance, which is very important and essential. Advisory for startups, understand risk boundaries and personal liabilities. Investor due diligence, examine underlying risk beyond mere corporate facade. So this is all about lifting corporate well. In bullet, if you want to memorize that, what are the grounds where court are authorized by law to intervene into corporate governance when it comes to fraud, tax evasion, public interest, due diligence, legal compliance, SEBI, Income Tax Act, Companies Act 2013, and these landmark judgments of Supreme Court. So thank you so much. I would end here. Happy learning. Have a good day.